Webinars are online test. So today I'll brief about the exam process first. One, it will be online text test. It's objective in nature. The subjects are banking, CBS and IT, commercial law and accountancy, and fourth one is English. So maximum marks is 100 for each subject, and qualifying marks is 30% minimum. So for commercial law, accountancy, cover questions on both subjects, but candidates will have the option to answer questions on commercial law or accountancy or both as per their choice. So we'll discuss about commercial law. So today I'm going to discuss about negotiable instrument, sale of goods, partnership act, letter of credit, bill of lading, insurance, insolvency laws, and Indian company laws. So one by one, we'll be going through. So this webinar is for 2 hours. So I have divided into two parts. First part, that is up to 1.5 hour, half an hour, we'll be discussing about all these concepts. And last half hour, we'll be utilizing for question and answers. And I have designed a poll so you can answer these questions. First one is negotiable instrument. So first one, we'll discuss about Negotiable Instrument Act 1881. So this act came into force in 1st March 1882, and it is applicable to whole of India. So documents specify payment to a specific person or the bearer of the instrument at specific day. So as per section 13, it defines three kind of instrument. One is promissory note, bill of exchange, and check. So negotiation means transferability and instrument means piece of paper. So put together negotiation and instrument, it's called negotiable instrument. So section 13 defines all three kind of instrument. So what are the three kinds of instrument? One is promissory note, which is defined in section 4, and one is bill of exchange, which is defined in section 5, and check, which is defined in section 6. So in exam point of view, one question may come here, which section defines negotiable instrument? So section 13 defined negotiable instruments, and there are three kinds. One is promissory note, second is bill of exchange, and third one is check. So one by one, we'll go through all these instruments. So before that, what are the features of negotiable instrument? We'll go through. It should be in writing. It is freely transferable, and right of a person to receive money and a corresponding liability of a person to pay money. Holders title free from defects. Transferability is infinitum. That means it can transfer or go hand from one hand to another infinite times. So first one, as per section 4, it is called promissory note. What is promissory note? It's an instrument in writing containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of certain person or the bearer of the instrument. So how many parties are there in promissory note? There are two parties. One is maker and second one is payee. So there are two parties in these slides. Another question, two question may come. Which is the sections defined in Negotiable Instrument Act, which define promissory note? Answer will be section 4. And how many parties are there in promissory note. So there are two parties to promissory notes, maker and pay. We'll try to understand with an example. For example, A has sold goods to B on credit for rupees 100 and B is supposed to make the payment after 1 month. This is as per agreement. Okay. So in that case, there are two parties, A and B. So B will draw a promissory note like below. So the promissory note will state that I agree to and promise to pay A or order the sum of rupees 100 for the value received after 1 month. This is only example. There can be, the wording may change, but some things will be very, very important, and that we'll see in the next slide. The maker and pay must be certain. It must contain an undertaking to pay. And third thing, promise to pay should be unconditional. And stamping is essential. And it must contain date. So as per Limitation Act, the limitation period for promissory note is 3 years. So there must be a promise to pay. So in previous example, we have seen B is making a promise that he will make the payment after 1 month. So this is as per Section 4. Section 4 of Negotiable Instrument Act 1881. We'll go to the next session, next section, that is Section 5. Section 5 of that Act defines Bill of Exchange. So what is a Bill of Exchange? Bill of exchange is an instrument in writing containing an unconditional order signed by a maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So for question number 1 from this slide, it may come, which section define Bill of Exchange? So Bill of Exchange is defined in Section 5. So how many parties are there in Bill of Exchange? There are 3 parties. One is drawer, second is drawee, and third is pay. So who is a drawer? The person who gives the order to pay or who makes the bill is called a drawer. Who is directed to pay is called a drawee. When drawee accepts the bill, it's called the acceptor. The person to whom payment is to be made is called pay. Again, another example we'll take, it will be more clearer. For example, A has sold goods to B. A has sold goods to B on credit for 100 rupees. And again, A has bought goods from C for 100 rupees. So A has bought goods from C and B has bought goods from A. And the payment terms is 1 month. After 1 month, A has to make the payment to B and C has to make the payment to A. So instead of paying A paying to B paying to A and A paying to C, A will draw a bill of exchange directing B to make payment to C. So A will draw a bill of exchange directing B to make a payment to C, reducing these two transactions technically into one. So that's why the name bill of exchange. Two bills are being exchanged. So whose work is getting reduced? So A work is getting reduced. That's why A will make the bill of exchange. So there are 3 parties. So A will be the drawer here, B will be the drawee, and C will be the pay. So this is specimen of bill of exchange. Again, in that example, Mr. A is the drawer. He is telling 1 month after date, pay Mr. C, that is pay a sum of rupees 100 for the value received. To whom it is saying? It is saying to B. That's why B is drawee. Yes. Again, in bill of exchange, few things to remember. Parties should be certain, must be stamped, and it should be dated and drawn place should be there. There should be order to pay and time of payment should be there. Amount payable should be there and it should be drawn unconditionally. Okay, so as per Negotiable Instrument Act, promissory note and bill of exchange are to be stamped. Check is need not to be stamped, but bill of exchange and promissory note are to be stamped. So we'll go to the next section. Next section is check. Check is defined in section 6. So a check is a bill of exchange drawn upon a specific banker and payable on demand, and it includes the electronic image of a truncated check and a check in the electronic form. So check is basically a bill of exchange only, but how it differs from bill of exchange, it is drawn on a specific banker and it is always payable on demand. So bill of exchange can be of two types. It can be of site, it can be of usance. So bill of exchange, if it is on site, that means the payment has to be done on demand. That means on site. But if a usance period is given, in our example we have taken, it is 1 month. That means it is a usance bill of exchange. So check is a bill of exchange, but it is of site basis or it is payable on demand. And second thing, it is always drawn on specific banker. Hope it is clear. So what are the classification of negotiable instrument? So it can be bearer instrument and a order instrument. It can be inland, it can be a foreign instrument. When there is a trade transaction happening inland and the drawer, drawee and payee are all inside the country, then it is an inland instrument. If any foreign party is involved, then it is called a foreign instrument. Demand instrument and time instrument already we have discussed. Demand and time instruments are basically based on the tenure of the instrument. That means demand and time instrument will make, in case of demand and time instrument, the payment will be on site. For usance, it will be on some time period will be given, like 90 days, 120 days, 180 days. Okay. So some of the important section will go for Negotiable Instrument Act 1881. Some sections will discuss from exam point of view. These are very, very essential. So section 18, it says that if the amount undertaken or ordered to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or ordered to be paid. Basically, section 18 says if in a check or in a negotiable instrument, the amount stated in figures and amount stated in words are differs, then words will prevail and make payment will be made on the basis of words only. So as per this is section 18 of Negotiable Instrument Act 1881. Then comes negotiation. What is negotiation? When an instrument is transferred from one person to another with a view to make the other person as a holder, then instrument is deemed to be negotiated. So how can it be negotiated? It can be by delivery and it can be by endorsement. What is by delivery? If it is a bearer instrument, by simply delivery, it is getting negotiated. But if it is an order, then there should be endorsement and plus delivery has to happen to make the negotiation complete. Hope it is clear. So this is the definition of endorsement: signing at the back of the instrument for the purpose of negotiation. So signing a check for the purpose of transferring to someone else is called the endorsement of check. So how many times one can endorse? So you can endorse at the back of the check. If no space is left, then another uh, page can also be added. So there is no limit. In the first slide itself, we have discussed the negotiation is unlimited. That's why the name called negotiation or negotiable instrument. Hope it is clear. So there are types of endorsements are there, various types of endorsement. One is endorsement in blank or general endorsement. when the endorser put his signature only on the instrument and does not write the name of anyone to whom or to whose order the payment is to be made, it is called endorsement in blank. What is endorsement in full? If the endorsers, in addition to his signature, also mention the name of the person to whom or to whose order the payment is to be made, so there is a direction added by endorsers to the person specified called the endorsee of the instrument, whom now become its payee and entitled to sue for the money due to the instrument. So if addition name is there, additional name mentioned in the check, it is called endorsement in full or special endorsement. What is conditional endorsement? An endorsement is a conditional where it negates the liability of the endorsement. That means upon happening an event, I will make the payment. For example, I will make the payment if you clear the CAIIB exam. So it's a conditional endorsement. So what is restrictive endorsement? It seeks to put an end the principal characteristics of negotiable instrument and seals it for the negotiability. It prevents the risk of unauthorized person obtaining payment through fraud or forgery and drawers losing his money. This is called restrictive endorsement. What is sans recourse? Sans recourse, which means without recourse or reference. It means whoever is endorsing it negatives his liability and excludes himself from responsibility to all subsequent endorsees. So when he's endorsed to someone else, it is basically saying, don't go back or come back to me. So it is called sans recourse. What is partial endorsement? Transfers the amount mentioned in the instrument partially and not fully is called a partial endorsement. As per section 56, it is invalid under law. So a question may come whether partial endorsement is allowed as per Negotiable Instrument Act or as per prevalent law. No, as per section 56, it is invalid. So we'll take one example here. So B is endorsed by B and it is endorsed in favor of A. So if B is signed without writing anything about the signature, it will be called blank endorsement. So if B is writing pay to A, it will be called endorsement in full. If B is writing pay to A only, it's a restrictive endorsement. So payee or endorsee cannot endorse it further because it is clearly mentioned that pay to A only. So if pay to A without my responsibility, that means don't fall back on me or there is no recourse, then it's called sans recourse. Pay notice of decision or waived. It's called facultative endorsement where endorsers undertake additional obligation. It is just the opposite of sans recourse. Partial endorsement already we have discussed. Pay to A 5,000. The check of amount is 10,000, but the drawee is telling to pay only 5,000 and it is telling, so this is invalid as per 56. Section 56. Pay to A if he completes his studies within 2 years. This is called conditional endorsement. So in exam, one question may come like, pay to A if he completes his studies within 2 years. So what type of endorsement is this? Whether it is blank endorsement, endorsement in full, sans recourse, or conditional endorsement. So answer will be conditional endorsement. Okay, so if it is signature of A is signed by B, again it becomes a forced endorsement. So hope you have understood the endorsement part. We'll go to the next part in negotiable instrument, that is crossing. So there are three types of crossing. One is general crossing, one is special crossing, and third one is non-negotiable crossing. So from exam point of view, section 123 defines general crossing, and one question may come, which section defines general crossing? So answer will be 123. So what is general crossing? Crossing a check refers to a drawing two parallel lines, transverse lines on the check or the corner of the check. So it basically indicates that the payment cannot be made over the counter and you have to have an account to make the payment. So right, you can see the right hand side of the slide where crossing is there. So these are called general crossing by simply to parallel line or account pay and account not negotiable. This is called general crossing. So general crossing is defined in section 123. One probable question may be, so what is special crossing? It is defined in section 124, which section defines special crossing as per Negotiable Instrument Act 1881. It is section 124. So it says that payment cannot be made only through the bank mentioned in the crossing. I mean, payment can be made only through the bank mentioned in the crossing. So you can see one specimen I given: State Bank of India and Co-State Bank of India, account pay, State Bank of India. All these are types of special crossing or restrictive crossing. So restrictive crossing is a broader term. Special crossing is little bit narrower, where banker's name is mentioned. That means payment will be routed through that bank only. So it gives more protection than general crossing. So in crossing, 123 defines general crossing and 124 defines special crossing. What is not negotiable crossing and which section defines it? 130. Section 130 of Negotiable Instrument Act defines non-negotiable crossing. That means here we'll see a person taking a check crossed generally or specially, bearing either in case of the words non-negotiable shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. That means it says that not negotiable crossing will not add or will not give a better title from whom he took. Okay, it's a warning of when the paying and collecting banker to be more take more precaution in case of payments. Okay, so three crossing already are discussed. Let me reiterate again. Section 123 defines general crossing, 124 defines special crossing, and section 130 defined non-negotiable crossing. So crossing after issue. So when you can do crossing? So one question may come from this slide. I will discuss that. Where a check is uncrossed, the holder may cross it generally or specially. That means a person has received a check and which is uncrossed, he may add a crossing which may be of generally or specially. When a check is crossed generally, the holder may cross it specially also. That means he can add a banker name there. When a check is crossed generally or specially, the holder may add the words not negotiable. And when a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker, his agent or collection. So the last point, fourth number point, pertains to our clearing of check, and where we receive the check and we can again specially cross the check and send for collection. So one question may come in the exam, uh, after receiving the check, whether we can cross or especially generally cross check can be crossed specially. The answer is yes, we can. The holder can do it. Another important section, section 131 of Negotiable Instrument Act, non-liability of banker receiving payment of check. It says that a banker who has in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself shall not, in case the title to the check proves defective, incur any liability, provided there are three conditions. The banker has received the payment of a cross check and collection was made by bank on behalf of customer, and collecting bank must have acted in good faith. That means if the three conditions are met, then there is no liability of banker. So this is as per section 131. So condition may be asked, or section, the most probable question may be which section defines, as per which section of Negotiable Instrument Act, non-liability of banker receiving payment of the check in good faith and without negligence. The answer is section 131. So section 138 to 142 talks about dishonor of check. So section 138 talks about the penalty. Penalty is imprisonment up to 2 years or with a fine up to twice the amount. So in this slide also another 2-3 questions are there. Which section defines of the penalty of a dishonor of check? Answer is section 138. So as per section 138, imprisonment up to 2 years or with a fine up to twice the amount of the check or both. So there are some conditions. Dishonor of due to insufficiency of the fund, obviously, and check was issued should have been discharge of a legally enforceable debt or liability. That means there is a consideration, there is a debt, there is a liability. And third thing is check should have been presented within 3 months. That means it is not a stale check. If the three conditions are there and the drawer has failed to make the payment, then 138 is applicable dishonor of check. We'll go to the next section. So what is the procedure? First, drawer has to give 30 days notice to the drawer. Payee has to give a notice to the drawer, 30 days notice, then 15 days again time period to make payment, and total time limit is within 1 month he has to give the file. The filing should be within 1 month. We'll see the jurisdiction. If the check is delivered for the collection through account, the branch of the bank where the payee or the holder in due course, as the case may be, maintains the account is situated. That means if the check is through collection, then the payee or holder in due course where he is maintaining that account, jurisdiction of court will be in that. And if the check is presented for payment by the payee or holder in due course, otherwise through an account, the branch of the drawee bank where the drawee account maintains the account is situated, the jurisdiction court. From exam point of view, it may not be that relevant. So as per section 143A, subsection 1, interim compensation can be awarded which should not exceed 20% the amount of the check amount. So, interim compensation, here is one question, should not exceed, what is the percentage? The percentage is 20%. So again, the drawer can go to appellate. That appellate is as per section 148. So here interim compensation as per section 143, that is one question. Percentage, what is the percentage? Compensation, interim compensation may be 20% of the amount of the check. And another question may be, so drawer can go to appellate court as per section 148. And here also appellate court may order the appellant to deposit such amount minimum of 20%, which basically says that the interim judgment, that interim compensation 20% he has to pay, plus the amount payable under appellate court also should be 20%. So these two questions, 20% and 143A and 148 may be a question in the exam. So as we have completed the first section of our presentation or of our discussion, I'd like to take a poll and you please attend this poll so that can you see the poll in the screen? Yes. Which of the following section in Negotiable Instrument Act deals with bill of exchange? So another happy news we can give. Yes, so 67% has given the answer section 5, which is correct. So section 5 defines bill of exchange. So another questions we'll discuss. Don't write in the chat box. Instead, please attend the poll so that we can see the result here. How many of you are giving the correct answers? I've got only 2 responses. I encourage everyone to participate in the poll. Yes, most of you are correct. I think everyone is correct. Section 6 of Negotiable Instrument Act defines check. Another question. Section 4 of Negotiable Instrument Act 1881 deals with yes, most of you have answered correctly. The answer is promissory note. Section 4 of Negotiable Instrument Act defines promissory note. So we'll take another question. The question is coming in front of a screen. The parties of bill of exchange are yes, absolutely. Those who have answered the 4 or D is the correct answer. Drawer, drawee, and pay. As we have already discussed, there are 3 parties in a bill of exchange: drawer, drawee, and pay. And in promissory note, there are 2 parties, and in bill of exchange, there are 3 parties. So one more question we'll take. Section 123 of Negotiable Instrument Act 1881 deals with check crossed specially, set of bills, check crossed generally, check crossed with condition. Yes, most of you have answered correctly. Answer is C, check crossed generally. So generally cross check is defined in section 123. 124 defines check crossed facially, and 130 defines non-negotiable crossing. Hope it is clear. Yes. If a materially altered check is paid and the alteration is not visible, even after the careful examination of the check, the bank is protected. Under which section? So options are 87 of NI Act, 89 of NI Act, 85 1 of NI Act, and no protection is available. So many of you have answered 131, but in option there is only 87, 89, 85, and no protection should be available. Yes, the correct answer is 89 of NI Act. Mr. Ramesh, Adarsh, Bhanu, Sai, and Hina Praveen, they have answered correctly. So under section 89 of Act, materially altered check is paid and the alteration is not visible even after careful examination of check, the bank is protected. Yes, absolutely, Diksha and Pavan. You are absolutely correct. 89 of NI Act. So another questions we'll take. Which of the following is a material alteration? A bearer check converted to order, a special crossing converted to general crossing, crossing a check, all of the above. Many of you have seen that, I mean, in chat you have writing that you are not able to see the polls. So in notification it will come and you have to click that. Then only you will be able to participate in the poll. So which of the following is a material alteration? A bearer check converted to order, special crossing converted to general crossing, crossing a check, all of the above. Yes. So Diksha, Rajini and Hina Praveen madam has again correctly, they have pointed out special crossing converted into general crossing is called material alteration. A general crossing may be converted into special crossing, but a special crossing cannot be converted into a general crossing. If it happens, it will be called material alteration. One more question. Holder in due course is defined under which section of NI Act? Holder in due course is defined under which section of NI Act? Options are section 10, section 9, section 18, or section 20. Yes. Shiva Krishna, Vanu, Kranti Kumari, Rajesh, yeah, opted it correctly. Section 9 defines holder in due course. Again, one more question we'll take. Not negotiable crossing has been defined under which section of the NI Act? non-negotiable crossing. Options are 147, 130, 118, 142. Yes. Mr. Pavan, Srivaschala, Sai, Ramesh, you're correctly opted out. Opted. 130 is the section. Option will be the second one. 130 section of not negotiable crossing has been defined in section 130 of Negotiable Instrument Act. Thank you. Thank you very much for your participation. We'll go to the next topic. Next topic is on Sale of Goods Act. So all the topics we are discussing today in Negotiable Instrument Act will have a higher weightage, and most of the more question may come in commercial law from Negotiable Instrument Act. So this act also is important, but 1-2 question we can expect from this Sale of Goods Act in 1930. So first thing we have to remember, Sales of Goods Act 1930. This is the law. This is the act, and where sale is defined. Sale is defined in section 4. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So there may be a contract of sale between one part owner and another. So this is where sale is defined. One question may come. Sale is defined in section 4. Section 4 of Sale of Goods Act 1930. Again, in that section itself, agreement of sale is defined, where the transfer of property in the goods is to take place at a future time or subject to some condition thereafter to be fulfilled. So one example we can take in case of a builder, usually they make an agreement to sell because the product is not ready. So it is subject to time, future time, and subject to some conditions. That's why it is called agreement to sell. So which section defines it? Section 4 of Sale of Goods Act 1930. So section 5 of Sale of Goods Act defined contract. What is a contract? Contract of sale is made by an offer to buy or sell goods for a price and the acceptance of such offer. Contract can be made, it can be writing, it may be word of mouth, it can be partial writing, partial word of mouth, or maybe implied from the conduct of the party. Contract need not be necessarily in writing. So contract can be for existing as well as for futures. So section 4 talks about sale, section 5 talks about contract, and contract can be of future, it can be of existing goods. It can be for existing goods, it can be for future goods. Which section defines it? Section 5. Section 5 defines future contract can be existing or for future goods. Ascertainment of price. Section 9 of 1930 Sales of Goods Act. So when the price in a contract or sale may be fixed by the contract or may be left to the fixed in a manner thereby agreed or may be determined by course of dealing between the parties. So when there is the price is not determined in accordance with the foregoing provision, the buyer shall pay the seller a reasonable price. This is as per section 9. So one question may come, under which section buyer has to pay seller a reasonable price? The answer is section 9. Again, condition and warranty. A stipulation is a contract of sale with reference to good, which are the subject thereof may be a condition of warranty. Section 12.1. So 12.1 of Sale of Good Act 1930 clearly defines condition and warranty. Another question here may come, section 12.1 of Sale of Good Acts, condition and warranty, where it is defined. So when condition to be treated as warranty? when a contract of sale is subject to any condition or to be fulfilled by seller, the buyer may waive the condition or elect to treat the breach of condition as the breach of warranty and not as a ground for treating the contract as repudiated. So this section may not be important, but section 12.1 condition and warranty, one question may come. Is my PPT visible? Sikha has written PPT is not visible. Can other please confirm whether it is visible or not? Yes. Yes. Okay, we'll go ahead. Sikha, can you please check your, you may go out again, log in once again, please. Okay, we'll go to the next one. In a contract of sale, there is an implied warranty that the buyer shall have enjoyed quiet possession of goods. The goods are free from any charge. So, from exam point of view, it may not be that relevant. Again, section 8, goods must be ascertained, and sale of ascertained goods and appropriation is defined in section 8. I am not going in detail because from exam point of view, 12.1, section 5, section 6, these are important from Sale of Goods Act 1930. So buyer to apply for delivery, section 35 says about it. Installment or deliveries, section 38 talks about it. Buyer has the right to examine the goods, whether previously buyer has not examined. So he has all the right to examine. This is as per section 41. So buyers is not bound to return the rejected goods. This is as per section 43 unless and otherwise agreed, where goods are delivered to the buyer and he refuses to accept them. Having the right to do so, he is not bound to return them to the seller. But if it is there any agreement is there, then he is bound to return the goods. So unpaid seller's right. This is as per section 46, lien on the unpaid goods. That means the buyer is not paying, then the seller has the lien on unpaid goods. If it is in transit, he has all the rights to stop that goods in transit. Withholding delivery of unpaid goods. That means if it is unpaid, then he can withdraw the delivery. Resale of unpaid goods. He can resell that unpaid goods also. He can suit against the buyer for unrealized price. Let's say one good is sold for that consignment is sold for, let's say, 100 rupees and the buyer has paid only 60 or 80 rupees. For that remaining 20 rupees, one suit can be filed by the buyer. So suit against the buyer for damages. If the buyer has damages the good, then one suit can be filed by the buyer. Refusal, cancellation, repudiation of the contract made earlier with the buyer will be uh, so buyer has the right to refuse, cancel, and repudiate the contract because of non-payment by the buyer. So suit for realization of interest as time value of money. If one time is given, let's say 1 month of time, and buyer is paying after, let's say 3 months, for the 2 months, that interest he can also claim. So these are all the rights of unpaid seller. Which section defines it? Section 46 of Sale of Goods Act 1930 defines it. Suit for a price, damages for non-acceptance, that already we have discussed. These are section 55 and 56. So these sections may not be relevant, but you need to go through if you are preparing for the exam. We never know when one section may come. Okay, we'll go to our next section, that is Partnership Act 1932. It came into force on the first day of October 1932. So partnership is defined in section 4 of Partnership Act 1932. It says that it is a relation between persons who have agreed to share the profit of a business carried on by all or any of them acting for all. So which section defines partnership or partnership act? Section 4. Persons who have entered into partnership with one another are called individually partners, and collectively it is called firm. And the name under which the business is carried is called firm name. It's simple, easy to understand. So types of partnership. So section 7 and 8 defines types of partnership. So partnership for a fixed period, particular partnership, or partnership at will. So these are the three types of partnership. When the time period is fixed, gets automatically dissolved on the expiry of the fixed term, it is called partnership for a fixed period. And if it is not getting dissolved, it is called partnership at will. That means after that fixed term, if it is continued, and it will be treated as partnership at will. Particular partnership, where it is formed for carrying on particular ventures. So one situation may be given, and option will be there. Choose the correct one, whether it is partnership at a fixed period, whether it is a particular partnership or partnership at will. Section 11 talks about the right and duties of partners by contract between the partners. So in the event of the death of the partner, his heirs or legal representatives or their duly authorized agents have the right of access to and to inspect and copy of any book of the firm. So section 12 talks about that conduct of the business. That means in the event of ABC firm is there, and let's say in between there is a death of the partner B, then B legal heirs or legal representatives have all the right to access, to inspect, or to go through the books of the firm. This is as per section 12 of the Partnership Act 1932. Section 18 talks about that all partners are agent of the firm for the purpose of the business of the firm. So all partners are agents, and every partner is liable jointly with all the partners and also severally for all acts of the firm done while he is a partner. So every partner is uh, liable jointly and severally. Which section defines it? Section 25 of Partnership Act 1932 defines it. Again, section 28, 29 defines where partner death happens and the business continued in the old firm name, the continued use of that name or the deceased partner's name as a part of thereof shall not of itself makes it legal representative or is estate liable for any act of the firm done after his death. Again, section 29 talks that if the firm is dissolved or if the transferring partner ceases to be a partner, the transferee is entitled as against the remaining partners to receive the share of the asset of the firm to which the transferring partner is entitled for the purpose of ascertaining that share to an account as from the date of dissolution. Yes, these things you need to remember. Section 30, when a person who is a minor according to the law and to which he is subject may not be a partner of the firm, but with the consent of all the partners for the time being, he may be admitted to the benefits of the partnerships. And in such cases, he will not be liable for acts of the firms, but the minor is not personally liable for such act. That means as a partner, he is liable, but as a minor, he is not personally liable for such acts. Which section talks about is section 30 of Partnership Act 1932 talks about it. So if that minor becomes major, what is the provision in Partnership Act for? 1932, and at any time within the 6 months of attaining majority of his obtaining knowledge, he had been admitted to the benefits of partnership, whichever date is later, such person may give public notice he has elected to become or that he has elected not to become. That means within 6 months he has to give a notice whether he wants to continue in that partnership or not. And if he is not giving such notice, it will be deemed that he is a partner. So here one question may come. within how many times he has to give the notice. So notice time period is 6 months. And one question may be, if he fails to give such notice, what will happen? If he fails to give such notice, by default, he will become the partner of the firm. So section 35 talks about where a contract between the partners, the firm is not dissolved by the death of the partner, the estate of the deceased partner is not liable for any act of the firm done after his death. Subject to the contract between the partners and to the provision of the section 30, no person shall be introduced as a partner without the consent of all existing partners. So section 31 says without the consent of all the partners, one partner or any other partner cannot be introduced. And section 35 says that when a partner is deceased, then the estate of the deceased partner is not liable for any act of the firm done after his death. Section 35 talks about it, and 31 talks about introduction of any partner without the consent of all the partners. This is again another important sections of Partnership Act 1932. So these things will leave it. What are the mode of dissolution? We'll see dissolution by agreement, section 40, dissolution by operation of law, adjudication of all partners or involves insolvency of any of the partner, unlawful for the business. One may be on the happening of certain contingency like expired or the fixed term to carry out one or more adventurous undertaking by the death of the partner or by adjudication of the partner as a insolvent. So these are the four modes. So dissolution by notice of the partners at will, section 43 talks about it. Dissolution by intervention of court, section 44 talks about it. So section 45 says that notwithstanding the dissolution of the firm, the partners continue to be liable as such to the third parties for any act done by or any of them which could have been an act of firm if done before dissolution until public notice is given for the dissolution. So may not be important from the exam point of view. We never know. Section 45. Just to have a look, I have put this slide. Section 49 says where there are joint debts due from the firm, also separate debts due from any other partner, the property of the firm shall be applied in the first instance in the payment of the debts of the firm, and if there is any surpluses, then the shares of each partner shall be applied in the payment of his separate debts paid to him. So in case of settlement, section 49 applies. So after a firm is dissolved, every partner or his representative may, in the absence of contract between the partners, to the contrary, restrain any other partners or his representative from carrying on similar business in the firm name or from using any of the property of the firm or his own benefit until the affairs of the firms have been completely owned up. So section 57 talks about appointment of register of firms and deputy assistant register. Okay, so this slide is more important. Effect of non-registration. Section 69 talks about it. In detail, we'll talk about it. Section 69 of Partnership Act 1932 talks about effect of non-registration. If a registration is mandatory, no, it is not mandatory. If we are not registering, what are the effects? It is defined already in Partnership Act. No suit can be filed against a partner of the firm if it is non-registered. If no suit can be filed against any third party, no suit to enforce any right for the dissolution of the firm or for account of a dissolved firm or any right or power to realize the property of a dissolved firm shall be instituted in any court. That means you cannot file a suit against a partner, you cannot suit against your debtors or a third party, and in case of dissolution also you cannot go to a court of law. So these are the effect of non-registration. It is defined in section 69. One question may come from this slide. So mode of giving public notice, again, it should be it should be in a vernacular newspaper, official gazette, and in at least one vernacular newspaper. May not be important, that much important. So in Partnership Act, there is a thing called Clayton Rules. It is very much relevant when a debtor owing several distinct debt to one person makes a payment which is not sufficient to discharge all the debts. The question arises which particular date of payment to be applied. That means, let's say a partnership firm has three debts and one credit comes, which date or which um, liability has to be adjusted first. The Clayton rules provides the same. And again, it has been discussed in the Indian Contract Act, section 59, 60, and 61 talks about it. We'll talk about this 61, what it says. 59 of Indian Contract Act. We are not talking about Partnership Act now. We are talking about Indian Contract Act. It says that 59 says that appropriation by debtors. That means if several debts are there, so debtors makes payment either with express intimation. That means liability 1, liability 2, and liability 3 are there, and debtor is saying that you give that credit to the liability 1 only. That means you have no choice but to appropriate in liability 1. Again, section 60 of Indian Contract Act says that the creditor may apply it at his discretion to any lawful debt payable to him from the creditor. So section 60 of Indian Contract Act says if there is no evidence or no instruction is there for debtors, so creditor can apply it as per his discretion. So appropriation by laws, section 61 provides that. 51, 60, and 61 of Indian Contract Act says that the payment shall be applied in discharge of debts in the order of time. In the order of time means FIFO, first in and first out. That means when the first debit has happened, when the credit comes, it will apply to the first debit only. So that is called appropriation by law. So one question may come, appropriation by law is defined under which section of Indian Contract Act? The answer will be section 61. Okay, this is a summary of it. 59 talks about appropriate, different appropriation. Okay, we'll move ahead. So we have now completed partnership firm. What is the act prevailing? And there is a concept called limited liability partnership firm. So LLP Act came in 2008, and LLP rules 2009. So as per this LLP Act, so there are 81 sections, 4 schedule, and 29 forms. We'll see what are the features of limited liability partnership firm. It's a hybrid of corporate and partnership business firm. It limits liability of partners to the extent of their contribution. That means whatever capital they're contributing, their liability will be up to that extent. It provides a flexibility without imposing detailed legal and procedural requirements. The organization and operation are the basis of mutual agreement. So these are the features. Again, body corporate, it's a separate legal entity, perpetual succession, limited liability. As we have seen in Partnership Act, the liability are several and joint. So in this case, their liability is limited. So non-applicability of partnership firm. This is also one of the features of LLP. Similarly, unlimited number of partners, limited liability of the partners. This is the repetition of that. No exposure to the personal asset of the partners except in case of fraud. If in case of fraud, then only personal asset will be exposed, otherwise no exposure to the personal asset of the partners. So no liability of the partner for the wrongful act of the other partners. The in Partnership Act, it is the liability are, I told you, it is several and jointly. That's why any wrongful act done by another partner is binding on another partner. But in case of limited liability partnership firm, it is not binding. So this is the one added advantage. So an individual or a body corporate can be a partner. That means a foreigner can also be a partner in LLP in India. So one question may come, in a LLP, limited liability partnership firm, whether a foreigner can be a partner. Yes, of course, he can be a partner. So body corporate can also be partner. That means limited liability partnership registered under LLP, company incorporate outside India, they can also become a partner in LLP. Not only individuals, body corporate, that means companies can also become a partners in limited liability partnership firm. Okay, these things are in detail. So next topic, we'll talk about letter of credit and bill of lading. So before going into letter of credit and bill of lading, few things you need to understand. One is imports, how imports have been regulated. It is regulated through Foreign Trade Development and Regulation Act 1992. And who is the designated authority? Director General of Foreign Trade, or DGFT, under Ministry of Commerce and Industry, is the regulating body for importing goods by land, sea, or air. So any kind of imports are being regulated through Foreign Trade Development and Regulation Act, and it is regulated by DGFT. So imports can be by letter of credit, imports can be through a bank collection, or import through a direct dispatch, or it may be advance payment for imports. So since the topic is letter of credit, so UCPDC, how we can live? UCPDC full form may come. One question, what is the full form of UCPDC? The Uniform Customs and Practice for Documentary Credit, and it is issued by ICC, International Chamber of Commerce, with where is the headquarter? Headquarter is in Paris. Sai has mentioned that screen is not visible. Whether it is visible, can another please check? Yes, I think other has confirmed that it is visible. Uh, Pooja madam, you have written FEMA 199. We'll come to that. We'll come to that. So we are talking about letter of credit. So letter of credit are governed by Uniform Customs and Practice for Documentary Credit, and which is published by ICC. ICC means International Chamber of Commerce. So these rule apply to LCs only. LC is also called documentary credit. The other name of LC is called LC is documentary credit. So what is the latest version of uh, documentary credit? One question may come. So UCP 600, UCP 600 is the latest version of UCPDC. Yes, absolutely. Yes, Pooja madam, you are correct. UCP 600 is the latest version of UCPDC. So another terms, Incoterms or international commercial terms. This is a full form of Incoterms. Again, this is issued by ICC. First, it was issued in 1936. See, we are going to discuss about letter of credit. That's why the build up. I mean, UCPDC you have discussed. Now we are discussing Incoterms so that you can relate with letter of credit. So Incoterms latest version is 2020. So from effective from 1st January 2020, Incoterms 2020 is applicable. It has 18 defined terms. We'll see the terms. These are the terms: X works, free carrier, free alongside ship, FOB, free on board, CFR, cost and freight, CIF, cost, insurance and freight, CPT, carriage paid to, CIP carriage and insurance paid to, DPU delivered at place unloaded, DAT deliver at terminal, DDP delivery duty paid. So these are the Incoterms. How many Incoterms are there? The total 11 Incoterms are there. So what is the latest version of Incoterms? Incoterms 2020, which is applicable from 1st January 2020. Okay. See, what does it mean? What does Incoterm means? So if a buyer is purchasing goods from a seller, so if the invoice mentions that X work and certain amount is mentioned, let's say $1 lakh rupees, that means buyer has all these liability, buyer has all the responsibility to take the goods from the X work. That means where it is produced from that place to buyer place, buyer has the responsibility. So when from X work it is going to CFR, cost and freight, that means the seller will take care of freight and cost. Cost is the actual good, I mean cost of the goods plus freight. When from CFR it is going to CIF, cost, insurance, freight, that means the seller is taking care of cost plus insurance as well as freight. That's why the amount of invoice, I mean the amount mentioned in the invoice will be of higher amount with compared to X work. Hope I am clear. Can someone give a thumbs up if are whether you are getting or not? Whether you are able to follow the Incoterms. Yes, we'll move ahead. So letter of credit or documented credit is an instrument by which bank undertakes to pay a seller for his goods, provided the seller complies with the condition laid out in the letter of credit. It's a commercial instrument for assured payment and widely used by the business community. So LC are governed by UCPDC 600 published by ICC. There are 39 articles in UCPDC, and as per all UCPDC, all LC are irrevocable. So what are the benefits? It protects against failure of importer to pay. This is the benefit to exporter, availability of financial support to exporter, and for importer ensures quality of goods by stipulating documents. So importer can stipulate documents which can ensure the quality of goods by a third party document, and buyer need not to make advance payment. These are the advantages of letter of credit for importer. So this is the basic transactions. There is a sale contract between applicant and beneficiary. In the stage 1, you can see there is a contract between applicant and beneficiary. Beneficiary doesn't know who is the applicant, and that's why he need a confirmation for payment. That's why he says to applicant, go to your issuing bank, go to your bank, regular bank, and issue a letter of credit. So letter of credit will go from issuing bank to advising bank. That is stage number 3. And from advising bank, it will go to beneficiary bank, which is stage number 4. So after receiving this letter of credit, beneficiary will make the goods and will make ready for shipments, which is step number 5. So after that, again, the shipment will go from beneficiary to applicant, but the documents will be written. I mean, right hand side, you can see the stage number 6. It will go to advising bank. So advising bank, or it will be called a negotiating bank, then he will send this document to the issuing bank. And again, issuing bank will release the document to applicant. That means banks are handling the documents and will releasing to applicant. So there is a secure way of making payment. So letter of credit assures that it's an undertaking. So there are many parties: applicant or buyer, beneficiary, issuing bank, advising bank, confirming bank, negotiating bank, reimbursing bank. So since LC is a documentary credit, by that mean negotiation of certain documents should be submitted. This includes invoice, packing list, bill of lading, insurance copy, certificate of origin, bill of exchange. All these are documents stipulated in letter of credit. So bill of lading, airway bill and lorry receipts is the soul of letter of credit because that is a title to goods, or it's called quasi-negotiable. Bill of lading is also quasi-negotiable. That's why in the next slide we'll discuss about what is a bill of lading. So bill of lading is a document which acknowledges receipt of goods delivered to a general ship for carriage of goods and is negotiable. So right hand side you can see I have given a bill of lading. So it is issued by a shipper, that is shipping company issue bill of lading. It is also a document of title of goods described therein. So you can see in the middle, PO number is written, style number is written. So goods is described there and it is a title to goods. It contains the terms and condition of carriage. Backside of this bill of lading, there will be terms and condition of carriage which have been agreed upon the parties. So there can be different type of bill of lading. First one is a clean bill of lading. What is a clean bill of lading? A clean bill of lading is the one not indicating any defects in packing. So when we are opening LC, we always mention a clean bill of lading has to be produced. But what is a clause bill of lading? Clause bill of lading contains some qualifying remarks about the quality of packing. So if any remarks is there, it is called clause bill of lading. So clean bill of lading, clause bill of lading. One question may come, what is a clean bill of lading? So when goods are to be carried partly by sea and partly by land, it is called multimodal bill of lading. That means some part it is covered by a truck or by land, the movement is happening in land, and other part is happening in by sea, then it is called multimodal bill of lading. So in a received bill of lading, one kind of bill of lading may be received bill of lading. The ship owner only acknowledges the receipt of goods for shipment in a particular ship without mention of time of shipment. That means shipper is telling that I have received the goods. It doesn't talk about the shipment or the voyage. But onboard bill of lading is better because it indicates that when that goods has been shipped or it has been boarded in that ship. So we always prefer clean bill of lading and onboard bill of lading. Clean and onboard bill of lading is stipulated in LC always. Hope you are following me. And another law we'll talk about, law of insurance. So it is a contract whereby any person called as an insurer, assurer, or underwriter undertakes to make good the loss of another called the insured or the assured by the payment of money to him on the happening of a specified event. So the consideration is called premium. One question may come, in insurance, the consider for which insurance undertakes to indemnify the assured is called premium. So we all know that it is called premium, but the wording will such that it may confuse you. That's why the consideration for which the insurer undertakes to indemnify the assured is called premium. The policy itself is not a contract, it is just the evidence of the contract. So some principles are offers and acceptance, lawful consideration, competency, pre-consent, lawful object, certainty and possibility of performance. So some specific principles we'll discuss in detail: utmost good faith, insurable interest, indemnity, subrogation, proximate clause, mitigation of loss, and contribution. First one is utmost good faith. What is utmost good faith? Whenever you are taking a insurance, you must declare all the material information about the subject matter. Otherwise, in the latter case, if the insurance company knows that you have hidden some facts, he may cancel the insurance in spite of paying the all the premiums. So that is called utmost good faith. Insurable interest. The insured should be economically benefited by the existence of the subject matter and should suffer an economic loss on its non-existence or at the death of the insured. This is called insurable interest. So some question may come. I think I have a multiple poll also. It is there. Indemnity. The principle of indemnity states that under the policy of insurance, the insured has to placed after the loss in the same financial position in which he was immediately before the loss. And if the loss is, let's say, 100 rupees, compensation cannot become 105 or 110. So that is the principle of indemnity. So one situation will be given, let's say one question will be the insured has to be placed after the loss in the same financial position in which he was immediately before the loss. So as for the law of insurance, which principle it is, whether it is principle of indemnity or principle of subrogation or principle of utmost good faith. So you have to identify the principle. So principle of indemnity. So there are different type of insurance. One can be life insurance and one can be general insurance. So life insurance principle of indemnity does not apply. What does it mean? It means that we cannot indemnify life. For general insurance, it can be fire, it can be marine insurance, it can be a health insurance, it can be a insurance for your house, it can be a bulgari insurance, where insurance company can indemnify, but life cannot be indemnified. So that's why principle of indemnity does not apply to life insurance. So indemnity applies to all other general insurance. Okay. What is subrogation? Law of subrogation. Transfer of rights and remedies from the insured to the insurer who has indemnified the insurer in respect of the loss corollary to the principle of indemnity. Insurer is substituted in place of insured for rights and claims. That means, let's say insurance has given the claim, that means he has all the rights, he has all the claims what you were having previous to the loss. So that is called subrogation. And again, subrogation is only up to the amount of payment. Again, principle of mitigation of loss means minimize or decrease the severity of loss on the part of insured. So insured has the legal, he has the responsibility to mitigate the loss. That, let's say I have taken a car insurance and unfortunately I met with an accident and my damage is 50,000. Let's say I'm assuming it is 50,000. I will not do any act to make the claim as 60,000, or I should not increase the loss to 60,000 or 1 lakh rupees. I should protect the loss. So the insured must act reasonably in the event of loss to make the loss minimum as far as possible. That is called mitigation of loss. Similarly, proximity clause, the rule says that what is the immediate cause that has to be regarded. So in an event, there may be different clause, but which clause or which uh, cause is immediate, that has to be reckoned, and if it is covered, then only insurance amount will be paid. That is called proximity clause. Contribution. The right of the insurer who has paid a loss under a policy to recover a proportionate amount from other insurer who are liable for the same loss. That means a company has taken 5-6 insurance for the same amount of goods and he have paid premium. So every insurer will have the who has paid this amount, he has the right to recover from other insurer, and that is called contributions. So in insurance sector, who is the regulator? Insurance Regulatory and Development Authority, IRDA, is the regulator of insurance sectors. And there is a concept called ombudsman rule in 2007. It has come for insurance sector and it was amended up to 2023. Okay. So it is called Council for Insurance Ombudsman. Fine. We'll talk about insolvency law a little bit. So the main aspects of Insolvency Act are to protect the embarrassed debtors from harassment by his creditors and to ensure expeditious and equitable distribution of his assets among the creditors. So a person can be adjudged insolvent only if he is a debtor and has committed an act of insolvency. An act of insolvency is something done or suffered by a debtor which gives jurisdiction to the insolvency court to adjudge him as insolvent. So from insolvency, from exam point of view, I think insolvency and bankruptcy code 2016 is important. 1-2 question may come. We'll discuss that questions only. So applicability of IBC, IBC full form is Insolvency and Bankruptcy Code, which is come into effect from 2016. So if a failure of the company or LLP where minimum amount of default is 100 lakhs, that means 1 crore and above, IBC will be applicable. One question may come if whether this failure of the company or LLP where default is more than 1 crore, then IBC will come into picture. Again, for individual and partnership, the default amount is 1,000, which is yet to be notified by IBC. So for the time being, so LLP and company we have to remember. So what does that IBC do? Insolvency and Bankruptcy Code 2016 is a consolidated law which deals with reorganization or restructuring, insolvency, and winding up or dissolution. These three things it does. And what are the pillars? Again, this law is divided into 5 parts, 7 chapters. It provides rights for SARFAESI and DRT, provision regarding insolvency and liquidation. Companies have been put in force from 1st of December 2016. Provision relating to bankruptcy of individuals are yet to be brought into force, that already we have discussed. So these are the 4 pillars of IBC. One is Insolvency and Bankruptcy Board of India, that is IBBI. This question may come, what are the 4 pillars? So for 4 options will be there, which one is not there, which one is there? This kind of question may come. First pillar is Insolvency and Bankruptcy Board of India. Second pillar is NCLT and NCLAT. Then information utilities, insolvency resolution professionals. These are the 4 pillars under IBC 2016. So who can initiate this resolution process? So financial lender or financial creditor, let's say we are given a loan, above 1 crore rupees outstanding, 1 crore rupees is there, then we can initiate this insolvency if he's not paying. Operational creditor, input and service provider, these are called operational creditor. They can also initiate resolution process. Corporate debtors, its shareholders or employees, they can also initiate the resolution process. So this is the resolution process. So if resolution is not happening, then it will go for liquidation. So what is the full form of COC? Creditor of committee of creditors. If the majority of creditor of committee of creditors, that is more than 60% decided to liquidate the corporate debtor, then liquidation will happen. If COC does not approve a resolution plan within 180 days with additional 90 days, that means 270 days, COC does not approve, then it will go for liquidation. If NCLT rejects the resolution plan, again it will go for liquidation. And debtor contravenes the resolution plan, then also it has to go to liquidation. So we'll see here waterfall mechanism. So in case of liquidation, the first thing will be the liquidation amount will go towards cost and fee of the IRP and liquidator. Second, workmen dues for 2 years preceding the date of liquidations and debts payable to secure creditors. Secure creditors means we banker, sometimes we take the property, we take the stock and book dates. So these our loans are covered by security. So these are called secured creditors. In the second page, it will come. In the third step, it will come. Third stage, it will go to wages and dues of the employees preceding 1 year. So one question may come from waterfall mechanism, which is the first stage, which is the second stage. So then debts payable to unsecured creditor, then government tax dues and unpaid secured creditors in equal proportion. Then it will go to other remaining debts and dues, preference shareholder, then at last it will go to equity shareholders. This is the waterfall mechanism under IBC 2016. Here you can see government tax due and unpaid secured creditor has gone far below, and wages and dues to employees has the precedent over it. Okay, I'm skipping some of the part. We'll go to the next law, that is called Indian Company Laws or the Companies Act 2013, where it defines company. How it is defined means a company incorporate under this act or any previous company law. In other words, a company is a legal entity which is formed by different individuals to generate profits through their commercial activities. So limited companies are owned by shareholders and run by directors. So company is entitled to own and hold property. A company can sue and can be sued in its own name. A company is has a distinct legal personality and its shares are easily transferable and having limited liabilities. See, it has separate legal entity that shares can be transferred, perpetual successions. That means in the eyes of law, companies has a perpetual succession and it is a separate legal entity. It has a common seal. It has a separate management. That means shareholders and managements are different, and it can have contractual rights. So we'll see in how many types of companies are there based on public interest. One is private limited company, where the number of members are minimum 2, maximum 200. In public company, 7 or more, and the maximum numbers can be unlimited. In a government company or PSU company, the paid up share capital is more than 51%. For foreign company, which is incorporate outside India but has a place of business in India, it is called foreign company. So as per section 13, it defines memorandum of association. There are two documents which is essential for limited companies. One is memorandum of association and article of association. So section 13 talks about memorandum of association. Okay, section 30, what is memorandum of association? Memorandum of association, a company defines the object for which the company is formed and various business activity that it can undertake and the liability for its member. Article of associations is the rules and regulation relating to the internal management of company. This one question may come that rules and regulation is defined which document of the company, whether it is memorandum of association or article of association. Answer will be article of association. Okay, so section 31 talks about register of company. Section 41 stipulates that in case of public limited company, certificate for commencement of business is necessary before it commences business. For private limited company, it is not mandatory. Commencement certificate. Fine. So we'll see two distinction between private limited and public limited company. Minimum numbers in private limited is 2. In public limited, it is 7. For maximum number, 200. In public limited, it is unlimited. Minimum director for private limited is 2. For public limited, it is 3. Quorum of AGM, 2 members minimum is requirement. In public limited, 5 members. Transfer of shares is restricted in private limited company, where in public limited it is free. Start of business. Certificate of incorporation is not mandatory to start a business in private limited company, but for public limited company, certificate of incorporation, and certificate of commencement of business, both are necessary. Minimum paid up capital for private limited company, there is no minimum capital. For public limited company, the minimum requirement is 5 lakhs. Hope we have covered some of the topics. So there are another types. One is public limited, private limited. There is another type that is called small company, which is defined in Companies Act 2013. It says section 285 of the Companies Act says that a small company where the paid up capital of the company should not exceed rupees 4 crore and turnover of the company should not exceed 40 crore. Then it will be termed as small company. We'll see a uh, diagram where it will be clear first whether it is a private limited company. If it is yes, then only it will be eligible for small company. If it is no, then it doesn't apply. Small company rule doesn't apply. Then if it is a private limited company, if the paid up capital is more than 4 crore, again if it is yes, then you have to see annual turnover is exceeding 40 crores or not. If it is not exceeding, then only it will be treated as small company. There are several benefits of small companies, like no need to prepare cash flow statement, no need to prepare or abridged annual return is enough. Mandatory rotation of auditor is not required. Auditor of small companies not required. A part are required to report on the adequacy of the internal financial control. There are various uh, several benefits for small person company. Fine. So we are coming to the end of the presentation, and whatever we have discussed, now we'll go for a question and answers. So I have sent you one quiz. The regulator for insurance business in India is SEBI, RBI, Government of India, and or IRDA. Yes, Mr. Praveen, Samiksha, Aruna, Sagarika, yes, everyone has answered it correctly. IRDA, Insurance Regulator and Development Authority, is the regulator of insurance sector in India. Insurance, next question. Insurance is a contract which is based on a relationship, utmost good faith, friendship, religion. Absolutely, the answer is utmost good faith. The answer is utmost good faith. Insurance is a contract which is based on utmost good faith. That means whenever you are declaring or giving a filling a proposal, you have to give your all details. There should not be any concealment of material facts. This is called utmost good faith. So another question is coming in your screen. Yes, as per sale of good act, goods can be future, contingent, present, all of the above. Absolutely. All of you have, I think, answered correctly. The answer is all of the above. So as per sales, a sale of good act, goods can be of future, it can be contingent, it can be present. So all of the above is the correct answer. So next question on the way. The act related to sale of good is called next question. Next question on the way. The unpaid seller of the goods has the following rights. Does not loss is lien. Lien cannot be exercised. Losses is right of lien. Lost is right after generation of invoice. This is a tricky question. Please go through and spend some time, then answer. Unpaid seller of goods has the following rights. Yes, many answers Y, B, A. So correct answer is does not lose his lien. I mean, he does not lose his right of lien. That means buyer has not paid. So he has all the rights and all the rights to recover by this is a negative question. That's why there is a varied answers. A, B, C, every answer have come. So correct answer is actually does not lose his right of lien over the goods. Yes. So 50% has corrected when given correct answers. Yes. The next question. The price in a contract of sale may be determined during the course of contract, fixed by contract, fixed by market force, which is mentioned in contract. Mr. Naveen has answered A. Any other answers from others? Shailaja has given A. D. Okay. Rishit has given D. Good. Swami has given D. D. Yes. Yes. Again, varied answers A, B, D. The answer is all of the above. The price in the contract may be determined during the course of contract. It can be codified or it can be determined in a contract in writing, or it can be fixed by a market force, which should be mentioned in the contract. So answer will be D. Yes, Kranti, you are correct. All of the above. D is the answer. Yes, we'll go to the next question. An agreement to sell becomes a sale when? So there are two conditions, an agreement to become sale. So the two conditions, if it is fulfilled, then it will become a sale. So which is the answer? So many of you are answering C. That means when the conditions are fulfilled, subject to which the property of the goods is to be transferred. Mr. Rakesh has given option B. See, those of you are answering C, you are correct partially. You are correct partially. You can go to option number B. You can see the answer C is there also. So there should be two things. One is time elapses and condition to be fulfilled and goods to be transferred. So option will be B. B is the correct answer. When time elapses or the conditions are fulfilled, subject to which the property in the goods is to be transferred. Option is B. Yes, another question. Who issued the bill of lading or airway bill? The shipper, the carrier, the broker, or the exporter? Akhil is very quick. Sunita madam has given C. Aman, Bandita, Ramesh. Yes, the answer is A, the shipper. The shipper usually issue the bill of lading. The shipping company. Yes. Option is A. Yes. Another question. LC is an dash by the opening bank to pay subject to condition laid therein. Surety, it's a guarantee, it's an undertaking, it's a promise. Yes. Asne Rakesh Kumar has taken guarantee. Okay, guarantee. All of you are saying guarantee. Okay, Devashish has given A, surety. Swami is saying B. So UCPDC defines LC is an undertaking. So answer will be C, undertaking. C is the correct answer. Guna has correctly answered. So C, undertaking. LC is an undertaking by the opening bank to pay subject to condition laid thereon. Okay, we'll go to the next question. International Chamber of Commerce, ICC, has issued guidelines practices for LC transaction known as Aman Seleja D has they have given answer D. Yes. Any other answers? Absolutely. Gajendra Roy, Nabeen has given D. Sagarika has given UCPDC. Okay, option D. That means Rishit UCPDC. Absolutely, absolutely UCPDC. Uniform custom practice for documentary credit. Option D is the right answer. Most of you have given the correct answer. So another question, the buyer of the goods opening an LC is also called applicant, customer, exporter, advisor. Yes, Navya Sri Madam has given A, Amman has given A. Yes, Mega, applicant, okay. Akhil has given A, absolutely. Yes, yes, yes. Everyone is correct. Applicant is the correct answer. The buyer of the goods opening an LC is called applicant. Absolutely. We are all correct. Another question again from this LC and bill of lading. As per INCO terms, international commercial terms, CIF stands for cost interest rate, cost income freight, cost insurance freight, cost customs insurance and freight. Aman has given C. Good. Any other answers? Yes, absolutely. Cost insurance right is the correct answer. Option number C. So here the seller will bear the cost as well as insurance as well as the freight. So all three he has to bear. Another question on its way. Beneficiary in letter of credit is a importer, exporter, exporter banks, importer bank. Jyoti, Pinky, Aman, Nabia, all are given B. Option exporter, absolutely. Naveen, Samiksha has given importer. Exporter bank. Hari Prasad, Mr. Hari Prasad has given C, exporter bank. So let me again explain. Beneficiary of letter of credit is always a exporter. That means he needs a assurance that payment will happen. So importer will open that letter of credit through importer's bank and it will go to exporter bank. So actual beneficiary is exporter only, not exporter bank, only exporter. Okay, so option will be B. Sailaja, Pavan, Devasis, you are correct. Yes, another question is coming. The interim compensation under section 143, again, it pertains to Negotiable Instrument Act 1881, shall not exceed what percent of amount of check amount? 10%, 20%, 30%, 40%. Great, great. I think everyone has answered it correctly. The answer is 20%, that is B. Absolutely. One question may come, definitely may come. So what are the effects of non-registration in a partnership firm? No suit against any partner, no suit against any third party, no suit to enforce right of dissolution, all of the above. Absolutely, as we have already discussed, non-registration in a partnership firm is defined in section 69 of Partnership Act. So it says that you cannot suit against any partner, you cannot suit against any third party, any suit cannot be enforced for dissolution. So all of the above is the correct answer. So option D is the correct answer. All of you are correct. Congratulations. Yes. So next question is coming. Find the wrong one with regard to 4 pillars under IBC 2016. Information utilities, NCLT, NCLAT, insolvency resolution professional, liquidator. So two options we are getting, option A and D. I'll tell the right answers. So the answer is D. Liquidator not is one of the pillars under IBC. So information utility is one of the pillar. NCLT, NCLAT is another pillar, and insolvency IRPs are also one of the pillars of IBC 2016. So liquidator is the answer. Okay, we'll go to our next question. In waterfall mechanism, cost and fee of insolvency professional and the liquidator will be dash paid out of the sale proceed of the asset. That means what is the rank? We have talked about. Yes, Pinky Madam has given A. Yes, Shaileja has given A. Absolutely, absolutely. Yes, yes, absolutely. You all of you are correct. A is the correct answer. So in waterfall mechanism, cost and fee of insolvency professional will go first. So it comes in the ladder and in the top in the waterfall mechanism. Thank you. So we'll go to our next question. And this is the last question. Section 12A permit the NCLT to allow insolvency proceeding to be withdrawn with the consent of what percentage of voting share of COC? 66, okay. 66. 66. Option A is coming. See, 66 we have discussed, and we have discussed 90 also. The correct answer is 90. So as per section 12, it allows insolvency proceeding to be withdrawn with the consent of 90% of voting share of COC. So option is D. Okay, with this, we are coming to the end of our webinar. So topics we have covered. One thing I want to show you, these topics, this recording, we can get it in Union Vidya. You have to go to explore and all other courses, and you have to go to Arambh promotion process, and there you can find this commercial law. I mean, the Aram has started today and it will continue till 31st. So all the topics will be covered and all these details will be available in Union Vidya. Okay, so if you want to show, I mean, if you want me to show, I can show you here. This is Union Vidya. You are able to see my screen. Hope you are able to see my screen. Yes. So you have to go to explore. You are able to see my screen. Union Vidya, you have to log in. Your PF number is your user ID and it is OTP based. So you have to log in to Union Vidya and you have to go to explore and to go to all other courses here. Then there is RM promotion process here. You can see at last RM promotion process CSA 2 scale 1. Here commercial law, it is there. Commercial 1, 2, accountancy is also there, which will be covered subsequently. So today we have covered some topic on commercial law. And again, tomorrow 4 to 6 commercial law will be again the part topics, other topics will be covered. Yes. Apart from that, you can go to Knowledge Cafe, then promotion material, and here also you can access this PDF material. This recording will be available in Arambh, and this material prepared by our staff college will be available in this. You have to go to Knowledge Cafe and promotion material, again CSA2 scale 1 promotion material. All these documents will be available. Apart from that, we are also creating e-learning on various topics. For commercial law, there will be 3 e-learnings. For accountancy, there will be 2 e-learnings. And for other topics also there will be e-learning. And along with e-learning, there will be 30 questions. So you have to complete the e-learning and you can attend the MCQs over there. Apart from that, if you have any doubt, you can call us and you can message, you can email so that we can clarify. If you have any other concern, you can. Yes, Sagarika madam is telling where we can get the e-learning. Yes, e-learning, it will be published shortly and it will be live shortly. So it is not live as on date and you can attend these questions. So your exam is on February 22nd. So it will be shortly will be uploaded e-learning. My mobile number, someone has asked, my mobile number is 7708. I'll put it in the chat. My mobile number 7708 225576.